Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the healthcare lawyers at Epstein Becker Green, a leading law firm that has more than 40 years' experience serving clients in the healthcare industry nationwide.
Today on Diagnosing Healthcare, we discuss how government investigations and enforcement of COVID-19 related fraud in loan funding and testing have begun to ramp up and what businesses can expect next. Hello and welcome. I'm your host, Rachel Weisblatt. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Boston office. While the height of the COVID-19 pandemic and its direct impact on our daily lives finally feels like it's in our rearview mirror, government investigation and enforcement into COVID-related fraud is just starting to heat up. So far, enforcement agencies' priorities have focused on the low-hanging fruit, criminal prosecutions, and a handful of large-scale takedowns in the COVID-19 testing and clinical lab space. For example, with the Department of Justice announcing criminal charges against 14 defendants across the country for losses exceeding $143 million last May. Now, government agencies like the Department of Justice, Small Business Administration, and others are turning their attention to potential criminal and civil fraud related to the billions of dollars in federal loans distributed to corporations and small businesses as part of COVID-19 relief efforts. On today's show, we're going to talk about the COVID-19 relief funding programs that were available to individuals and businesses and that are now subject to enforcement actions, the type of government enforcement that we've been seeing so far, and what we can expect to see next, and perhaps most important, what businesses with concerns about this type of enforcement can do to prevent or mitigate potential civil and criminal charges. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Melissa Jampol, a partner at Epstein Becker Green and former assistant U.S. attorney and state prosecutor who has experience in healthcare enforcement and government investigation matters. And Sibley Bahnsen, also a partner at Epstein Becker Green, practicing in healthcare investigations and False Claims Act litigation defense. Both have been at the forefront of the CARES Act and COVID-19 enforcement defense. Thank you both for joining us today. The Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act, is a $2.2 trillion economic stimulus bill passed in March 2020 in response to the historic economic fallout of the COVID-19 pandemic. Erica, can you tell us a little bit more about this historic legislation?
Thanks, Rachel. As we all know, the CARES Act was designed to allocate funds to support individuals and businesses during the height of the pandemic, along with allocating around $300 billion in one-time cash payments to individuals and $260 billion in increased unemployment benefits. It also created the Paycheck Protection Program to provide forgivable loans to small businesses that was given an initial $350 billion in funding and was later increased to about $669 billion, an additional $500 billion in loans for corporations, and an additional $340 billion to state and local governments. The CARES Act also initially authorized $100 billion, which was also subsequently increased by about $75 billion per later legislation in direct payments to healthcare providers for pandemic-related healthcare expenses and lost revenues, largely distributed through the Provider Relief Fund.
Let's talk a little bit more about the Paycheck Protection Program and the Provider Relief Fund.
The Paycheck Protection Program, or the PPP, started in spring of 2020 and was administered by the Small Business Administration, or SBA. It began distributing funds designed to provide loans to help eligible businesses maintain their workforces during the pandemic. PPP received several rounds of funding by Congress. Eligible borrowers were able to receive completely forgivable, very large loans, up to $10 million in so-called first draw loans and up to $2.5 million in second draw loans. When the program ended in May 2021, the SBA had approved nearly 12 million loans totaling over $800 billion through over 5,000 public and private lenders. Because the goal of the PPP was to quickly distribute loans to businesses, the program relied on self-certification by participating individuals and organizations, really an honor system.
Melissa, how significant was the PPP financial support to the healthcare industry?
Rachel, it was vital. Financial support from the PPP to healthcare services totaled, according to one estimation that we've reviewed, nearly $60 billion during 2020, representing 1 in 9 PPP loan dollars. It's estimated that ambulatory services received the largest amount of loans, followed by nursing and residential care facilities. And hospitals in particular received approximately 1.8 of all healthcare PPP loans, which represented in general 6.4% of all healthcare PPP dollars.
Erica, can you tell us a little bit about the Provider Relief Fund and what that did for healthcare providers in the industry?
So, Rachel, the Provider Relief Fund, or PRF, as I'll be referring to it, provides direct provider payments to eligible providers who diagnose, test, or care for individuals with possible or actual cases of COVID-19, and also have healthcare-related expenses or lost revenues that are attributable to COVID-19. It's administered by the Health Resources and Services Administration, HRSA, within the Department of Health and Human Services. Providers who receive PRF funds are subject to certain terms and conditions. So, for example, providers are required to report details on their use of funds during the applicable time periods and must certify to the accuracy of their reporting before submitting this information to HRSA.
Are these PRF reporting obligations to HRSA still ongoing?
Yes. So there have so far been 2 reporting deadlines that have already passed, including 1 grace period. And the current PRF reporting is due September 30th, 2022, for providers who received more than $10,000 during the January 2021 to June 2021 time period. There are also currently 2 additional reporting periods scheduled in 2023. These terms and conditions are important. And so is a certification made at the time of reporting, because they can open up a provider who receives these funds under the PRF to potential False Claims Act liability based on the provider's use or misuse of the funds. We're seeing claims of FCA liability slowly pick up as time passes since the initial issuances of funds. This process takes time, sometimes several years, to become public. FCA claims are often based on whistleblower complaints, and the allegations remain under seal or not public while the government investigates the whistleblower's claims. Nothing will become public until the government decides whether or not that it will intervene in the case.
Melissa, are there other COVID-19 related funding programs that we haven't discussed yet that are subject to these enforcement actions?
Definitely. Other programs subject to enforcement include those such as the Economic Injury Disaster Loan Program and the Unemployment Insurance Programs. The Unemployment Insurance Program has been hit particularly hard with lots of scams. And in fact, I have numerous family members, friends who received claims in the mail that they did not file, which is a classic sign of this entire scheme. And we also have a number of clients who've been impacted, whose employees have been hit with having unemployment claims filed in their names that were fraudulent.
I know the Department of Justice, the DOJ, is a major player in enforcement actions. Melissa, can you talk a bit about the enforcement mechanisms that exist at DOJ to enforce compliance related to these COVID-19 programs?
Sure. Following up on what Erica was talking about before, which is there was a large amount of money distributed very quickly. The Department of Justice has stepped in to attempt to enforce the laws surrounding the use of those funds. For example, in May of 2021, Attorney General Merrick Garland established the COVID-19 Fraud Enforcement Task Force to marshal the resources of the Department of Justice in partnership with agencies throughout the government that DOJ works hand in hand with to enhance efforts to combat and prevent pandemic-related fraud. This year, in March, President Biden announced a COVID-19 enforcement czar to head up pandemic-related fraud enforcement. And the Department of Justice appointed a director for COVID-19 fraud enforcement to lead the department's criminal and civil enforcement efforts to combat COVID-19 related fraud. As Erica was just saying, it's going to take a while for these investigations to ramp up and for them to become public. A lot of these are covert at the beginning. And, we're going to see the results of these efforts shortly. In particular, Associate Deputy Attorney General Kevin Chambers has announced that he plans to focus on large-scale criminal enterprises, as well as foreign actors who the Department of Justice believes sought to profit at the expense of the American people. And so the DOJ plans will include strike teams to prepare for the next phase as the Department of Justice moves forward to fight pandemic fraud.
I know even before the appointment of the COVID enforcement czar this March, DOJ enforcement efforts had already resulted in criminal charges against over 1,000 defendants with alleged losses exceeding $1.1 billion, the seizure of over $1 billion in economic injury disaster loan proceeds, and over 240 civil investigations into more than 1,800 individuals and entities for alleged misconduct in connection with these pandemic relief loans, totaling more than $6 billion. Appointment of this enforcement czar has already ushered in the second wave of enforcement activity. What have we seen happening lately?
Well, Rachel, just to back up a little bit, at the beginning of the pandemic, the most egregious conduct, sort of what we call the low-hanging fruit, was charged. And we saw people who purchased luxury cars, houses, jewelry, and even an individual who allegedly purchased a Pokemon card. Those were criminal charges. Now the more complex investigations are beginning. And so companies that received PPP, CARES Act, provider relief funds, or economic injury disaster loans and funding have recently started to see more investigations that have become overt. And they've been seeing outreach from the DOJ, SBA, or other government agents in connection with potential criminal and civil fraud cases. There was actually a super timely and interesting article in the New York Times this week in which it was estimated that there are currently 500 people working on pandemic-related fraud cases across the offices of 21 inspector generals in the federal government. And that doesn't even include the usual government agents such as the FBI, the Secret Service, the Postal Inspection Service, and the Internal Revenue Service, or IRS. According to the New York Times article that I was just speaking about, the government has already charged approximately 1,500 people with defrauding pandemic aid programs. And they've counted that they've convicted more than 450 people of crimes to date. But those are dwarfed by the mountains of tips and leads that investigators still have to chase. In fact, agents in the Labor Department Inspector General's office, which is responsible for the unemployment insurance investigations, have what is estimated at 39,000 investigations that were going. And it's interesting, I was speaking to one of those agents recently, and that agent was indicating that they just have tons of these and that they're working nonstop on trying to get through the backlog of investigations. The New York Times article estimates that about 50 agents at the SBA are sorting through 2 million potentially fraudulent loan applications. So there's a lot of work still ahead. It's easy to say that even more enforcement actions are on the horizon in this space. From all accounts, DOJ has focused most of its efforts to date attacking the criminal side of the fraud equation, but we've seen some movement on the civil side as well. And as I often say, what one prosecutor thinks is a criminal violation, another prosecutor thinks is a civil or administrative violation.
Before we move on to the civil side, Erica, can you tell us a bit more about what's been going on in the criminal fraud space?
So, as Melissa was saying a moment ago, the low-hanging fruit for criminal enforcement has been the large majority of the early enforcement work. In a statement by Kevin Chambers on March 10th, soon after his appointment as director for COVID-19 fraud enforcement, he noted that the task force was going to target, quote, large-scale criminal organizations who are committing some of the largest and far-ranging fraud. And in the same remarks, he identified so-called overseas actors who saw our government's relief packages as an opportunity for personal gain as a priority for COVID-19 enforcement. That trend of targeting larger groups and takedowns has borne out in the enforcement trends we've seen to date.
One of those first enforcement actions that caught a lot of media attention was taken right after naming of Kevin Chambers as the director for COVID-19 fraud enforcement in April of this year, when the DOJ announced a nationwide coordinated enforcement action, what I always call a takedown, targeting COVID-19 related fraud involving charges against 21 individuals across 9 federal districts. And what the government has alleged was $149 million in false claims submitted to federal programs. In another recent example, a California man pleaded guilty earlier this month to a multi-million-dollar tax fraud scheme to defraud the IRS and the PPP program. Among other allegations, this individual used his tax preparation business to apply for PPP loans on behalf of a number of small businesses that were controlled by himself and his co-conspirators, some of which were professional athletes, and thereby grossly inflating the number of employees and payroll costs. They also allegedly submitted fabricated tax returns in support of these applications. So, according to the government, this individual faces a maximum penalty of 5 years in prison on his conspiracy charge and 20 years in prison for wire fraud. And there's more people involved in this particular investigation, and we're watching it to see where it goes.
Those are some pretty serious charges and penalties that they're facing for this type of criminal fraud. While slower to pick up speed, we're beginning to see some movement on the civil side as well. Can you speak a bit to that, Melissa?
Sure. As part of a larger False Claims Act settlement for alleged conduct, including unnecessary testing and upcoding of E&M related visits, the United States Department of Justice alleged that a company named Physician Partners of America falsely certified its application for PPP funding to the SBA and thereby obtained a $5.9 million loan. This company, Physician Partners of America, through its settlement, agreed to pay $24.5 million to the United States and the state of Florida to resolve the complaints against it. And, of note, they pointed specifically out the allegedly false certification to receive PPP funding as part of the settlement here.
I know we've been focusing our discussion so far on DOJ enforcement related to the PPP and EIDL funding. The Office of Inspector General, or OIG, is responsible for enforcement related to PRF funding. Erica, what enforcement have we been seeing out of OIG?
Rachel, we've seen a few OIG enforcement actions directed toward individuals who received PRF funding so far. By way of example, on September 9th of last year, 2021, Oasis Healthcare, Inc. and Quizana Walker of Stafford, Texas, entered into a settlement with OIG resolving allegations that Walker attested in her PRF portal that Oasis was eligible to receive a PRF payment because, among other things, Oasis was still eligible to bill Medicare. However, of course, at the time of the attestation, Oasis's Medicare billing privileges had been revoked and its participation in Medicare had been terminated. Similarly, in early 2022, John Pierce, a physician from San Francisco, California, entered into an $18,000 settlement agreement with OIG, resolving allegations that, again, he falsely attested in the PRF portal that he was eligible to receive PRF payments because, among other things, you are required to attest that he provided after January 31st, 2020, diagnoses, testing, or care for individuals with possible or actual cases of COVID-19. And Dr. Pierce settled on allegations that he did not actually provide diagnoses, testing, or care for any individuals after the start of the pandemic. OIG is also currently in the process of several audits related to dispersed provider relief funds as part of the agency's work plan. We're currently seeing in the work plan that there are audits of HRSA's controls over Medicare providers' compliance with the attestation and reporting requirements. We're also seeing one related to hospitals' compliance with the PRF balance billing requirement for out-of-network patients, which, if you are not familiar with it, part of the hospital attestation to receive PRF funds is a requirement that providers must not pursue the collection of out-of-pocket payments for presumptive or actual COVID-19 patients in excess of what the patients otherwise would have been required to pay if the care had been provided by in-network providers. So we're expecting to see some results of these audits out of OIG in the next year or so, and perhaps some enforcement based on their findings.
Erica, that's super interesting. We're used to OIG enforcing balance billing, and here it seems as though they're going in a different direction.
That's right, Melissa.
We know that pandemic relief funding went to thousands of businesses across different industries. Melissa, have any areas or industries been a particular focus of these enforcement actions?
Yes, Rachel. The Department of Justice for the last few years, even before the COVID-19 epidemic, was focusing on enforcement in the clinical lab space. And so with the massive influx of testing through COVID-19 and the ramp up by clinical labs in all different kind of ways in physician offices, freestanding labs, et cetera, there's been notable criminal enforcement in this area. So in July of 2022, just last month, the Department of Justice announced charges against what they said were 36 defendants who had committed $1.2 million allegedly in healthcare fraud relating to payment of illegal kickbacks and bribes by laboratory owners and operators in exchange for referrals of patients by medical professionals working with telemedicine and digital medical technology companies. The focus has been not only on COVID-19 testing, it's also been on genetic testing and is moved more recently into cardiac testing. So as we talked about earlier, there was another takedown in May of 2021 where 14 defendants across 7 federal districts were charged. And in particular, with the pop-up testing labs that became rampant during the height of the pandemic, it is a certainty that COVID-19 testing is going to be under the government's lens for some time in the future. As a result, those who receive COVID-19 funds who are also involved in the COVID-19 testing space should take great care to ensure that their processes are compliant with the PPP, for example, with the other relief funds that we've talked about today, as well as the usual suspects, the Stark Law, the False Claims Act, the Anti-Kickback Statute, and more recently, the Eliminating Kickbacks and Recovery Act, or ECRA, where we're just starting to see the first cases nationwide be prosecuted as well. And don't forget the state laws as well. We want to make sure that we cover those as well.
It will be really interesting to see what's coming next. I want to thank you both so much for taking the time today to address these important issues. And I'd like to wrap things up by asking just a few final questions. Melissa, we've talked a lot about the second wave of pandemic fraud enforcement that was ushered in by the appointment of the enforcement czar at DOJ. Are there any other recent developments that we've missed?
Rachel, I wanted to point out that on August 5th, 2 weeks ago, there were 2 bills signed by President Biden that both extend the statute of limitations for the enforcement of pandemic-related fraud. So the first one was HR 7334, entitled the COVID-19 EIDL Fraud Statute of Limitations Act of 2022, which establishes a 10-year statute of limitation for fraud by borrowers under the Small Business Administration's COVID-19 Economic Injury Disaster Loan Programs. And so this gives the SBA more time to investigate, as well as the other federal agents. The second extension of statute of limitations occurred in a bill labeled HR 7552, the PPP and Bank Fraud Enforcement Harmonization Act of 2022, which establishes a 10-year statute of limitations for fraud by borrowers under the Small Business Administration's Paycheck Protection Program. Kevin Chambers, the DOJ's chief pandemic prosecutor, recently said that there are, quote, years and years of work ahead for them, and that he is confident that they'll be using every last day of the 10-year expanded statute of limitations to pursue enforcement actions. Thus, as we repeated on this podcast, but I'm going to say it again, there's a long road ahead for government investigations in this space.
knowing that so much more enforcement is coming, what should a provider or a business that received pandemic relief funding that now maybe has concerns about its use or whether it followed the proper obligations or process with respect to the funding do? How worried should they be?
Well, as Eric and I have discussed at length, especially in preparation for this podcast, folks are really not out of the woods yet. These types of cases take time to develop, and I certainly saw that when I was a federal prosecutor. It takes years to put together complex cases. And the government has given us every indication that they're devoting substantial resources to enforcement efforts. The good news is, however, that businesses can absolutely take steps to be proactive before the Department of Justice or any other government agency comes knocking. There's definitely ways to get out in front of potential enforcement and work with the agencies or eliminate the risk of charges and enforcement in the future.
Melissa, Erica, thank you so much again for joining the show today. It was really a pleasure having you both here.
Thank you, Rachel.
Thanks. It was great to do this podcast with both you, Rachel, and Erica.
Thank you. And thank you to all of our listeners. I'm your host, Rachel Weisblatt. If you like what you've heard, please don't forget to subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.